Hey guys, today's video is a continuation on the series on defamation law in Singapore. Today we are going to talk about the defense of innocent dissemination. Now, the defense of innocent dissemination is generally available to third-party intermediaries such as newspaper retail sellers, newspaper distributors, libraries, and delivery agents, for example, people who deliver newspapers and magazines. An intermediary who participated in the distribution of defamatory material has to show certain matters, that he fulfilled certain matters before he can rely on these defense. The first matter that the intermediary has to prove to rely on the defense of innocent dissemination is that he did not know that the publication was defamatory. Number two, he has to prove that the circumstances or the work could not have alerted him to the defamatory statement or the defamatory content. Number three, the third-party intermediary has to show that such ignorance of the defamatory statement was not due to his negligence. So once the third party satisfies the above three requirements and can rely on defense, he has to make an offer of amends. What is an offer of amends? An offer of amends is a procedure under Section 7 of the Defamation Act, which allows a defendant, the person getting sued, to ward off a potential defamation lawsuit or to discontinue an existing one. That means after he is sued, he makes an offer of amends to discontinue an existing lawsuit. But first, he also has to prove that he had innocently defamed the plaintiff, the one suing, and that he exercised all reasonable care in relation to the publication which contains the defamatory statement. How does the defendant show that he did it innocently? Well, the defendant has to show to the court satisfaction that he did not intend to publish the defamatory statement and had no knowledge of the circumstances that the words in the defamatory statement might be understood to refer to the plaintiff, or that the words were not defamatory on the face of them, that means on the face of the publication, and that the publisher did not know of the circumstances by which they would be understood to defame the plaintiff. Under this defense and the offer of amends procedure, the defendant has to publish a correction of the alleged defamatory words and make an apology. This usually is done by way of newspaper advertisements. Further, the defendant has to take steps to inform persons who had been given copies of the defamatory publication. He has to take steps to inform them that the contents in the defamatory publication are defamatory. So, once an offer of amends has been accepted by the plaintiff cannot sue the defendant because that will be estoppel. He says stop. Once he accepts the apology and offer of amends, he cannot then later sue the defendant. But if the plaintiff does not accept the offer of amends and he decides to sue the defendant can then raise this defense of innocent dissemination during the lawsuit that he published the publication or the defamatory statement innocently, and emphasize to the court that an offer of amends was made as soon as possible, and that after the defendant knew that the words were defamatory. So thanks for watching this video on the defense of innocent dissemination.